This began on Tuesday. Time we.
Good morning, Your Honor. Nicole Underwood, legal guardian ad litem for the minor child.
Ms. Sasha Thomas, counsel for the department. Ms. Kelly.
Brittany Kelly for the department.
Michael Brooks, I represent the father, Harold Hollis. Harold?
Oh, yeah. Michael McFarland representing the mother. Please introduce yourself.
Eric Walker.
Did the court hear that?
Nope.
Eric Walker.
Thank you. All right, it looks like Ms. Walker was on the stand at the last juncture. Did anyone have any further questions for her before we move on to our next witness?
I did not.
No, Your Honor.
Not at this time, Your Honor.
Ms. Thomas, your next witness.
Your Honor, may I inquire if Ms. Brittany Moore is online? Yes. Your Honor, at this time, I would ask the court to allow for the LGL to call her so she can return to work.
Any objections? Gentlemen, any objections?
No.
No.
Very well. All right, Ms. Underwood. You can take the helm there. You might want to, yeah, I was gonna say, go ahead and use the podium.
Like you're sworn in, Your Honor?
Hmm?
Like you're sworn in?
Yes, but I know you, Ms. Underwood, do you want the podium moved to point towards the camera? That would be too
Well, I
long.
guess we'll find out.
As you can see, she's kind of, you're kind of sideways. It doesn't matter to me. But we couldn't move that podium so that you're facing the right.
Either way is fine.
Okay. Yes, please swear in Ms. Brittany Moore.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good morning, Ms. Moore. Can you hear me okay?
Yes, ma'am.
Please state your full name for the record.
Renee Moore,
And Ms. Moore, where is it that you work?
Moore Counseling Services, as well as Reading School District.
Okay, and what is your job title?
Therapist, licensed master's in social work.
And how long have you been a therapist for?
18, 19 years.
And how do you know the Hollis Walker family?
I did an assessment on Mr. Hollis.
Okay, and that was regarding the minor child?
Correct.
Okay, and you did provide a written report to the court regarding your recommendations for parenting time, is that correct?
Correct.
Did you schedule appointments with Ms. Walker to attempt an assessment?
Correct.
And how many appointments did you schedule with Ms. Walker?
Your Honor, I'm objecting. There's no court order that my client attend any appointments. The court is not taking jurisdiction. She's not required to make any appointments. So it's.
Your Honor, this is in response to any recommended parenting time that may occur if the court does take jurisdiction, so I believe it's relevant for at least those purposes.
Ms. McFarland, I believe I ordered an evaluation on counseling. I'm just looking through my past.
So am I, Your Honor. So I may have misspoken, but I didn't see it.
I know I had asked for a recommendation on parenting time, given the allegations that were contained in the first court order after the hearing conducted by Judge Costello, considering that I had not presided over that, and that there were still some unanswered questions as to whether or not it was safe. So overrule your objection because it's important to understand why and whether or not your client cooperated with that.
Ms. Moore, so how many appointments did Ms. Walker no call, no show for?
2 appointments. August 18th, 2024 and August 29th, 2024.
And you were able to meet with Mr. Hollis?
Yes, on August 16th of 2024.
You were able to watch him interact with the minor child?
The minor child was not there. I was there to talk with him and do an assessment on him.
I couldn't hear that.
Yes, Ms. Moore, could you get a little closer to your microphone? I think it's not picking up quite all of your statements there.
I apologize. I met with Mr. Hollis. I did not meet with a minor child. I just met with the parent to do an assessment for parenting time.
Excuse me, Your Honor, because it's a little distracting. Is that a horse with the witness?
Your Honor, that is Miss Moore's therapy pony that is there in the school, so.
Oh, it's just distracted me. I'm looking at it thinking, what is that horse doing there?
I apologize. I can see if a teacher can take her if you want me to.
No, I just never seen a horse in testimony before.
Trying to keep her out of the
Your
picture.
horse is fine, ma'am. Your horse is, I have no objection to your horse.
This is the first.
Any other objections to the horse?
No, we welcome
No,
the
Judge.
horse.
As long as he doesn't contribute.
All right, you may proceed with your next question.
Oh. Thank you for the clarification, Ms. Moore. You indicated that you were just there with Mr. Hollis.
Correct.
Okay, and what concerns do you have with respect to Mr. Hollis's ability to parent the minor child?
He expressed during the assessment how he had a heart condition. I could hear him wheezing. He talked about having difficulties with the walking, and he was being evaluated for yet another heart surgery. So I wanted more information as to his medical clearance because of the way that I could hear him breathing. My
Do you
concern.
have, go ahead.
My concern is his physical ability for a child, that's as young as his daughter is, to be able to keep up and move around and not hurt himself.
Your Honor, I am going to object in that I've not heard her qualified as a physician or anybody qualified to make those physical, medical statements.
Your Honor, I would respond and say that Mr. Hollis is the one that notified Ms. Moore of his health conditions. She was not making any diagnoses, just noting concerns.
Yes, I think I'm not taking her as an expert in any area of medical diagnoses, Mr. McFarland. And she is, however, an expert recognized for purposes of counseling as well as parenting recommendations. And that request for recommendation on parenting time was given to her, and it is relevant. The health concerns would be relevant for purposes of parenting time and parenting ability, which is how she has couched her inquiries. So for those reasons, I would overrule the objection. Does anyone else want to argue on the objection or raise a different point?
I support what Mr. McFarland said to the extent she's making diagnosis or assumptions based on medical knowledge. I object.
Fair. All right, overrule. Anyone else?
No, Your Honor.
All right, thank you, Ms. Underwood. And Ms. Moore, if you need the question repeated, great. If you want to keep going, also great.
Thank you, Your Honor. I'm not a medical expert. That's why I asked for further information to assess the parenting ability to keep up with the child instead of, because I don't want somebody who sits in a chair and says, come here, come here. I want a parent that can actively engage with a child.
Ms. Moore, do you have concerns regarding domestic violence in the home?
Mr. Hollis denied the allegations. I did have a police report that we reviewed together, but he denied the allegations.
Okay. After your assessment of Mr. Hollis, what is your current recommendation with respect to parenting time?
I had asked for further information on his health I asked him to engage in counseling, individual counseling, to address potential domestic violence, parenting, and substance abuse as indicated in the report, and then start off with 1 hour supervised visitation.
Okay, and you did submit counseling reports to the department, is that correct?
Correct.
Your Honor, Ms. Moore's reports have been submitted and circulated to all of the attorneys, so I would move that Ms. Moore's recommendations be admitted into evidence.
I think they were admitted without objection already.
I don't know that that was accomplished on record, but do you have any objections, Mr. Brooks?
No,
Mr. McFarland?
No position as my client. No.
Ms. Thomas?
No objections, Your Honor.
Thank you. All right, they are received as a wing of the court moving forward on, and I found it in the orders. It was actually issued by Judge Costello back in June for counseling to determine appropriateness and conditions of parenting time. A trauma assessment was also noted. So for those reasons, they are admitted.
I have no further questions, Ms. Moore, but the other attorneys might. Thank you for your time.
All right, Mr. McFarland, any questions?
No.
Mr. Brooks?
Ms. Moore, forgive me, and I don't mean to make light of the situation, but I need to know, what is your horse's name?
Dazzle, this one was Dazzle, and I also have Boots that goes to the elementary school.
That's all I wanted to know, ma'am. Thank you.
So Dazzle and then Boots is at the elementary school, is that what you said?
Correct.
All right, and I'm only asking because it's still a little bit hard to hear you. All right, any questions, Ms. Thomas?
Morning, Ms. Moore. Thank you for joining us today. I just have a couple of questions. As relates to your attempts to schedule with Ms. Walker, you stated that, can you just clarify, were two appointments scheduled and she did not attend?
Correct.
Do you have any concerns about a parent who does not attend a mandated or court-ordered session with you?
Motivation to modify the reasons that they came to court would be a concern.
Thank you. I have no further questions, Your Honor.
All right, any other questions for this witness from any of our attorneys?
I do. Ma'am, you, basically, if a parent doesn't show, you don't know if that's because they have lack of transportation, whether other situations other than just a refusal to cooperate. You don't know that from them not attending, correct?
If they choose the time in the day, then the basis would be that they have that available to him, to the person, but that is correct. I would not know, but I give it options of days and times, and then they pick. If that makes sense, what I do.
Right, but you don't know the conditions in which a person did not show up, correct? You're speculating what it might mean by them not showing, correct?
Correct.
Nothing further.
Mr. Brooks?
No, thank you.
Ladies?
Nothing.
Just one follow-up, Ms. Moore. Did Ms. Walker indicate or contact you and explain any reason why she couldn't attend the appointments that she scheduled?
No, ma'am.
Thank you. No further questions.
All right, any reason we should not thank and excuse Ms. Moore?
No objection.
No.
All right, you know what, I'm sorry, I do have a question. Ms. Moore, I know you know this, but the court is required to look at parenting time suspension only in the event that it may be harmful to the child. Do you see any reason, and I know you didn't get to meet with Ms. Walker, but based on your review of the case, do you see that there's any harm to this child, and would you want more information in order to make that determination?
I can't make a determination on Ms. Walker because I have not spoken with her. With Mr. Hollis, if it's supervised, you know, as I outlined in the recommendation, supervised for 1 hour, then you can go from there. Assess if he's able to parent and the child has a bond with him.
Would you be able or willing or have room on your calendar to facilitate that for him?
I could do that.
Thank you. Any questions based on my questions?
No, Your Honor.
No, nothing about you.
Mr. Brooks, any questions?
I'm sorry, Your Honor, my client was,
That's all right.
no, I have no further questions.
Ms. Underwood.
No questions.
All right, thank you so much for your time and your testimony, Ms. Moore, and that's all for this morning. You're welcome to be on with your day.
Thank you.
Right, your next witness, Ms. Thomas.
Thank you, Your Honor. I'll call Ms. Kelly.
All right, Ms. Kelly. come on, please.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you
Yes.
Good morning, Ms. Kelly. Can you state your full name for the record, please?
Brittany Kelly,
And Ms. Kelly, where are you employed?
Department of Health and Human Services for Child Protective Services.
And how long, what is your job title there?
I'm a CPS investigator,
And how long have you been employed with the department?
5 years.
And have you been a CPS investigator for those 5 years?
Yes,
And you signed the petition that's before the court today, correct?
I did.
Can you tell us a little more about how you became familiar with the Walker Hollis family?
I was assigned an investigation due to concerns of domestic violence. I attempted to meet with the family multiple times. Did meet with Harold on several occasions. Then I was able to meet with Harold and Erica at the same time, where we discussed the allegations and safety concerns. They did cooperate in that meeting. We attempted the safety plan. They would not sign the safety plan or finish the safety plan regarding domestic violence and substance use. They denied all the allegations. Based on the information I gained throughout my investigation, the case was open. I attempted a family team meeting. Mr. Hollis did participate in that. Erica did not participate. I attempted to engage with her several different times to set up meetings, to meet with Melanie, and to start services with the family.
Do you recall about when that family team meeting was that you, or I want to go back to dates. Do you recall about when you would have met with the parents to discuss the concerns about the complaint?
I believe it was the beginning of April or the end of March.
In your petition, you indicate that the complaint came in on April 15th. So when did you?
So it would have been within, we have a time frame to see children, so within 72 hours, I would have had to see Melanie.
Were you able to see Melanie within those 72 hours?
I was not.
What attempts did you make to see Melanie within those 72 hours?
I personally made multiple attempts to home visits. Harold was at the home most of the times. When I spoke with him, he did not have any knowledge of where Erica was, but just stated that Erica had Melanie and they were gone. We sent our CPS on-call worker out after hours to meet with the family to see if Melanie and Erica had returned to the home. They had not. I attempted calling Erica several times on multiple different phone numbers. I sent her an email with the email we have from our Bridges system. I texted her phone number multiple times and I was unsuccessful.
Do you recall at what point in time you were actually able to, let me backtrack that a little bit. Within the first 72 hours, were you able to speak with Erica and ask if she would be willing to meet with you?
I actually spoke with her on the phone while sitting in the driveway 5 minutes after that 72 hours expired.
And what happened?
I believe she stated that she would let me know when she could meet with me, which then was followed up by several text messages to try to engage with her to meet with me.
And you heard the testimony of Ms. Walker on the 9th, correct?
I did,
And you heard the dates that were read off through text messages between you two.
I did.
Were there any other contacts, like whether via phone call that might not have been explored on the record, or emails?
There were phone calls in between text messages. I don't have exact dates. It would be documented in my report.
Speaking of report, for today's trial and part of discovery, you have provided me and then subsequent through that, the other attorneys with 2 CPS investigation reports. Correct? Okay, and so we have intake 126040431, which the complaint is dated for 4/15/2024. And then there's an investigation ID an intake ID of 136020450 with a complaint date of 6/19/2024. Can you explain why there are 2 different reports?
The first one was the initial investigation that had began. And then in the process of the case opening, we received new allegations that prompted a new investigation to start.
Your Honor, may I approach the witness, please? Ms. Pye, I'm going to hand these reports to you. And if you need to refer to them to refresh memory, please let me know if you're doing that. In the first report, well, let me kind of backtrack here. What were the main concerns about the family in the original complaint that you got in April 15th?
We had allegations that there was a domestic violence altercation between Eric and Harold, that the child was present and possibly may have been hit in that process of the parents fighting.
And were you able to affirm or confirm, I should say, any of those concerns?
No,
Is domestic violence in general a reason to file a petition against a family and ask for removal of a child?
not always.
Is substance abuse in and of itself a reason to file a petition and ask for removal of a child?
No,
And is lack of cooperation with the department a reason to file a petition and ask for removal?
our policy states that if a case is open for services and the family is not cooperative with services, that is a reason to file a petition with the court.
So help us understand. You determined that it was necessary to open a case, correct?
Correct.
What are the other options? Like, what other dispositions do you have when you get an investigation assigned to you?
Well, there's 5 different categories. So category 5 would be no evidence or abbreviated case, say the family lives out of state. Category 4 would be a denial. So the allegations are untrue. We couldn't substantiate on them. Category 3, open close, would be they were substantiated on but provided outside resources for services. Category 3, open, would just mean that the case would be open for 90 days and monitored with this ongoing CPS worker. Category 2 would be substantiated on and open for more than 90 days. And based on the progress of the family, that would determine how long the case was open for. And category 1 is court involvement.
And at the for the first complaint, you determined that you needed to open a case.
Correct.
At what level?
Category 2,
And does that include court involvement?
not at the initial disposition, no.
And why did you determine that it arose to the level of a category 2 and not a 4 or 5?
Harold was being cooperative, semi-cooperative throughout the investigation. There were certain things that he wouldn't safety plan around. I had concerns that the family was violating the PPO that was in place at the time. I still couldn't make contact with Erica throughout the month of May. And I felt like they needed some services regarding healthy relationships, communication skills, possible mental health, possible substance use.
Did you have any other records or files available to you when you were making that determination?
I had a lot of previous police reports. I had previous ISPs from investigations through the department.
In your report, you indicate that there are 2 reports from 2022 in which there is domestic violence, or police reports from 2022 in which there is domestic violence alleged in those police reports. Is that accurate?
Correct.
Your Honor, I'm objecting as that would indeed be hearsay. Hearsay is not permitted at an adjudication trial.
I'm not offering it for the truth of the matter asserted. I'm offering it as, well, I actually haven't offered it yet at all. But I'm asking Ms. Kelly about it for the basis of categorizing the case as a level 2 and not a different level.
I would still say that she's relying upon hearsay. That is not allowed. We need an actual witness to generate the report.
Anyone else want to weigh in on this?
No,
I don't believe it's hearsay because she's not referring to what's in the report necessarily, just referring to what was utilized to form a decision at the time that the report or that the petition was being filed.
Yes, I agree. The objection is overruled. Ms. Kelly is not responsible for whether or not that information is true, but rather using it in order to properly categorize a complaint that she receives during the regular course of her obligations in her capacity as an investigator.
Right. Well, Your Honor, and with that, I would move to admit the 2 police reports that are referenced in the report.
I'd like to just order the witness on one question, Your Honor.
Okay.
You're not taking an opinion as to whether these reports are true or not, correct?
During my investigation, you mean?
Right.
Repeat the question, please.
You were not taking an opinion, having an opinion that these reports were true or not, correct?
I feel like that's hard to say yes or no to. I think they weigh in on my opinion while making decisions. If there are multiple police reports regarding the same concern in a household.
I don't know that was answered. No further questions.
I have the same objection, Mr. McFarland, just thinking about lodging. Police reports are hearsay.
And the reports are being used as a tool for the investigator to determine whether a case needs to be opened or a petition needs to be filed. So it's appropriate that if they are part of her report, then they should be admitted for that purpose.
I will refer back to the witness's own answers.
Yes, I am going to deny the admission of these particular records. We have established that record is clear that there were 2 incidents that were alleging domestic violence. And that was the reason for her actions moving forward. I think any further inquiry on this line would give the opportunity to perhaps misunderstand the purpose of what's contained in those reports.
I understand, Your Honor. Thank you. In addition to the police reports, you've also referenced in your testimony the PPO.
Correct.
How did you become aware that there was a PPO?
I honestly cannot remember.
Do you recall about when you were able to look at the petition for protective order or personal protection?
I believe it was about halfway through my investigation.
About when would that have been?
End of April.
And from the best of your memory, what in that petition, I guess, weighed in your decision making for the categorizing this complaint?
Once I had read the PPO that was filed, that was signed by Erica, I had concerns that she had not disclosed any domestic violence to me, but then had disclosed domestic violence to the shelter who in turn helped her write this PPO. That was filed and granted. later on in the investigation, I had contacted Ms. Walker to talk about a family team meeting, to schedule that, talk about services. While on the phone, I asked her where was she living at the time. She had stated that she was living at Harold's with Melanie. I could hear Harold talking in the background. And during that phone call, she had denied that she or Harold needed any services.
I'm sorry for the interruption, but while we're on this topic, was that during the period of time where the PPO would have been in effect, you know?
Yes.
Thank you.
In any of the other, like, were you able to explore any other records? I know that DHS kind of gets access to a lot, so were there any like medical records you're able to explore, or mental health records or anything like that?
I didn't explore those. Both parents had denied any services in that capacity, but Harold did, when we had the family team meeting, he did talk about early on with Melanie, and he said they had went to the first meeting of early on services for her, and then they didn't go to any after that.
And based on your first report, which is dated or signed by you on May 13th, what was your disposition for the case at that point in time?
We had substantiated for, I think it would be considered placing a child at unreasonable risk, for concerns of, the ongoing concerns of possible domestic violence. The parents weren't telling me that there was domestic violence in the home. However, I did locate the PPO that was active that they were violating. I was actively trying to offer services that were not being taken into consideration for them to start doing. But the ongoing concerns of possible substance use also. I had asked both parents to drug screen and they both refused.
During, did you speak with anyone else that might have, or did you have any other information that helped you form this opinion as well?
The history of domestic violence in the relationship, all of the police reports I had read throughout the years, and the PPO. Reading the PPO was, I think, a big eye opener for me. And the PPO, it states that there was domestic violence in front of the child.
Did you speak to any other family members?
I did. I spoke to Harold's sister throughout the case.
And did any of the information she provided you weigh in your decision?
I would say it had a small impact. I definitely take opinions of family members, especially when they're close to the family. She had let me know that, she was supportive of the family, that she had helped them build a fence for Melanie. They live on a busy road, cars go fast by there. So she had helped build a fence. Melanie is very active. So they had helped purchase fencing for them, put the fence up. They helped on the weekends, kind of with respite care, giving Eric and Harold a break. And they were supportive in that way to Erica and Harold.
Did she state that she had concerns for the child?
Yes.
What concerns did she have?
Objection, that would be hearsay.
Again, Your Honor, just asking for the information she used to formulate the basis of her decision.
Well, it's still hearsay. What did she say? I don't know how more hearsay you could have.
Hearsay is any statement asserted, court statement asserted for the truth of the matter asserted, I'm sorry. I'm not asking for it to be entered for the truth of the matter asserted, that whatever the sister said is true, but rather what formed the basis of Ms. Kelly's opinion.
Well, that's the case, and we don't need to know what she said.
Mr. Brooks,
I have no position on this.
Ms. Underwood,
I would echo what Ms. Thomas said. It's again, not used for its necessary truth for your determination. Is used for Ms. Kelly to compile facts for her investigation.
I will allow it strictly for that purpose.
Yes, Your Honor.
There were concerns for domestic violence in the home and possible substance use, possible untreated mental health as well.
So once you make a case open under category 2, that doesn't require petition from the court, correct?
Correct.
So what happens after that?
The case is open to an ongoing CPS worker for services, and then services are provided to the family.
What did that transition ever happen? Where you did an ongoing CPS worker ever become involved with this family?
There was a family team meeting that we completed with the ongoing worker and then Harold. And then the case was never fully, I wouldn't say it was transferred, but it was not fully started due to the new investigation coming in.
And so the new investigation that came in, that would be the intake 1360205 or 0450.
Yes.
And what was that new investigation relating to?
That was relating to a possible domestic assault occurred between Eric and Harold on June 16th, 2024. It had stated that Harold assaulted Erica. Erica was holding Melanie when Harold assaulted her. Melanie was not injured. Erica did not sustain any injuries for the assault. No one was arrested. And then there were concerns that Erica smoked dope with Melanie present.
Okay. At that point in time, did you what did you do to investigate that complaint?
I obtained the police report that happened on June 16th. I believe it was June 16th, but the police report originated out of Madison Township, but then Raisin Township was involved also. Madison Township handled speaking with Erica, and then Raisin Township handled speaking with Harold at his residence.
And what information, so that's part of your investigation is looking at a police report, is that correct? Did you do anything else to investigate the complaint?
I tried to meet with the family. I tried to locate any other police reports that had happened in the previous month. I don't think there were any that had happened between June 16th and then when that case had opened for ongoing services, when we did like the family team meeting and that stuff. But in the beginning of the second investigation, when our concerns were really raised as ongoing services hadn't really started, that Erica was still being uncooperative with meeting with the department, and there's still allegations being made and police reports being made that is saying that there's domestic violence in the home.
Was there anything else that from that specific incident that made you concerned for the child's safety or well-being?
In the allegations and in the police report, it talks about Erica was on the side of the road. She ran out of gas, and then she was hiding in a ditch with Melanie. It was late at night, and it talked about Erica's eyes were checked. There was no distortion of her pupils. It is unknown if Erica was under the influence at the time of the incident. I had concerns after reading the police report and the allegations that the police had looked at her eyes and.
Your Honor, here I am stating hearsay again, because now it's being used for the truth of the evidence asserted, and that based upon what the police said, she's forming a belief of truth. The police noticed that the eyes were, not only do we have the report, now this is what the officer's saying, we're using that for the truth of the matter asserted.
All right, Your Honor, Ms. Kelly never said that mom was using substances.
No, she said the police officer said that her eyes were, and here we're getting into,
Well, if you would let me finish my statement, she stated that her concerns were for the child's safety, included the fact that the police officer checked for whether mom's eyes were dilated or not. Not that they were and she was using. Do not believe that this is hearsay because again, it is not being used for the truth of the matter asserted.
Your Honor, I guess if it's not being used for the truth of the matter asserted, then it wouldn't have been used to bring this case forward. And to bring the case forward, it would have had to been used for the evidence that she's testified to. It's not just extraneous information that's not relied upon, it's relied upon. So that's my position.
Anyone else want to weigh in?
I agree with Mr. McFarland.
I feel like the hearsay exception is being not confused, but maybe misconstrued here. Again, Ms. Kelly can utilize any documents and information that she has to form an opinion on a case and use those things to determine whether a case needs to move forward. We're not asking that the police's statements are used in court today to be for the truth. What we're asking is, what is Ms. Kelly, was Ms. Kelly using to, again, figure out what's appropriate in this case when the petition was filed, when the case was being investigated, not for its actual truth. Ms. Kelly has to rely on statements from police, statements from people when determining what's going to happen in her investigation.
I agree with the reasons offered by Ms. Underwood, so I will overrule the objection. At this juncture, we do need to take a brief recess. Unfortunately, after I gave you this morning, had to schedule a couple of emergency hearings. So we'll need to take a break to handle those. What are the obligations that you have again this morning that may limit our time frame? Does anybody have anything they have to?
Your Honor, I was able to arrange that,
Okay,
so I'm okay.
all right, so we'll.
I'm
take a-
scheduled for 3 mental health support. I'm going to.
That's what we're taking. Mr. Brooks.
Interpreter.
Appreciate that. We're going to take a recess.